We've got a family fortune, a will that was meant to be set in stone, and a modern law that threatens to crack it all wide open. It's a high-stakes legal battle that's worked its way all the way up to the Supreme Court.
And it all boils down to one huge question. Can a law passed today literally reach back in time and rewrite the rules of a supposedly unchangeable will? The answer could end up affecting legacies all across the country. So let's unpack how we got here.
To really get this, we have to wind the clock all the way back to 1977. That's when the family matriarch and her husband wrote wills that were pretty much identical. After they passed away, these wills created a few irrevocable trusts back in 1992. And the whole point of these trusts was to be that financial fortress, protecting the family's assets for generations to come, with some very, very clear instructions.
And wow, was her intent clear. I mean, listen to her own words from the will. She basically says she never expects the core assets, the principal, to be touched. That money was supposed to be left alone, except for maybe the most extreme, unimaginable emergencies. This one rule right here is the foundation for this entire fight.
For a lot of years, everything went pretty much according to plan. But then, long after the will was written and the trusts were locked in, a new law showed up. And, well, it completely changed the game.
Just look at the timeline. The will gets written in 77. The trusts become unchangeable in 92. But it wasn't until 2006, a full 29 years after she signed the will, that Massachusetts passed this new law. And it took until 2022 for that law to be used to dip into the principle, which is what kicked off this whole conflict.
So what did this new law actually do? Well, it created something called the power to adjust. Basically, it gave trustees a brand new authority to move money from the principal bucket over to the income bucket. And that's exactly what the trustees started doing, arguing that this 2006 law gave him the right to do it.
And right here, this is the heart of the conflict. You've got the will from 1977 saying, do not touch the principal, plain and simple. But then you have this law from 2006 that gives the trustee a power that, well, it looks a whole lot like touching the principal. So which one wins, an old will or a new law?
This is the question that fuels the petitioner's case all the way to the Supreme Court. And he makes three really key arguments.
Okay, argument number one is what I like to call the time travel problem. The petitioner is basically asking, how could Helen Klein, writing her will in 1977, have used specific legal language to forbid a power that lawmakers wouldn't even invent for another 29 years? He says applying this law backwards in time is an impossible and unconstitutional burden.
The second argument is what the petition cleverly calls the Juliet rule. You know, a rose by any other name. The point is simple. You can call it a distribution, you can call it an adjustment, but at the end of the day, it's still taking money from the principal, and that's the one thing the will explicitly forbids. He's saying it's just a fancy new name for doing the same forbidden thing. And then we get to the most explosive claim. The petitioner points to what he calls a smoking gun. He's accusing the highest court in Massachusetts of being biased by selectively quoting from legal commentary just to back up its own ruling. So, in its ruling, the Massachusetts court used this quote from legal commentary. And, reading it, it seems to directly support their decision. It suggests that even old wills, like this one, that forbid invading the principal shouldn't get in the way of this new power to adjust. But, and this is a huge but, the petitioner claims the court conveniently left out the very next sentence. And that sentence completely changes the meaning. It says that only wills written after the law was passed need to have this new specific language. By leaving that part out, the petitioner argues, the court basically flipped the entire meaning on its head to justify its ruling. Now, the petitioner's case isn't just about these legal principles. It's also about the cold, hard cash. He claims that the principal he's supposed to inherit one day has been so poorly managed that it's barely grown at all in over 3 decades.
And according to the petition, the numbers are pretty shocking. Over 32 years, the trust's actual growth was just under 6% above inflation. Meanwhile, if that same money had just been put into a simple S&P 500 index fund, it would have grown by over 1,400%. I mean, the argument is that his inheritance has basically been frozen in time.
The petition also throws a bunch of other accusations out there. It claims the trustee misquoted the will, that the income beneficiary was improperly involved in decisions she shouldn't have been, and that the whole investment strategy was unfairly tilted to favor her. He even points out that in the trustee's own statements, he called the payments distributions, not these newfangled adjustments. So you might be wondering, okay, this is a messy family fight for sure. But why does it deserve the attention of the U.S. Supreme Court? Well, this is where the story gets much, much bigger than just one family. It's because the law at the very heart of this case, it's based on a national model called the Uniform Principal and Income Act. And get this, a version of this law has been adopted in all 50 states, plus Washington, D.C. It's everywhere.
What that means is, a decision here, it could set a massive nationwide precedent for thousands, maybe even tens of thousands of older, irrevocable trusts. It could literally redefine what it means to leave behind a permanent legacy. So let's boil down the petitioner's core constitutional claim. It's pretty straightforward. Step 1, he says the trust principle is his property. Step 2, the court's ruling is applying a new law backwards in time. Step 3, this action is taking his property away without due process. And that, he argues, is a direct violation of the 14th Amendment, turning this family fight into a federal case worthy of the Supreme Court. So we end up right back where we started. Should a will be a timeless command locked in forever? Or does it have to bend and adapt to the laws of the future? Is a legacy truly permanent, or is it always up for debate?